Benjamin, seem to focus on janitorial type services. What's the best analogy you can point us to the situation at hand?
Well, there's one regulation that talks about the fact that the carting of waste from one area to another is taxable, and I think that that's the situation. I disagree with RG&E's analysis of the regulations. The regulations point out two situations that are not taxable. Neither of those situations, Your Honor, has to do with whether or not what was being carted was trash. One has to do with whether or not what was being carted had resulted in the end result test of a capital improvement, which once again is the building contractor's case. And that has to do with the legal definition of what's being taxed here in terms of the end result. And the other one has to do with whether or not this was a regular service. Neither of them went to the issue here of whether or not what's being carted is trash. And we believe that the statutory language is clearly broad enough to cover the worthless byproduct of coal combustion, which is fly ash in RG&E's case, and in Seacoast International's case, it's the worthless byproduct of manufacturing. It's hazardous chemical waste. Insofar as the argument that this is a transportation service is concerned, we submit that, once again, it's worthless products that are being transported to landfills. You don't have a situation here where it's the transportation of a useful product. Trash removal, the very words trash removal from buildings necessarily include the pickup, the transportation, and the disposal. The Third Department in the Penfold case said that, and said that you can't logically separate out one particular action from another, that it's all part of an integrated service. Insofar as RG&E's argument that fly ash is not trash and Seacoast's argument that hazardous waste is not trash, neither of these arguments were raised in the court below. We believe that the issues were not preserved, but in any event, as I stated, the dictionary definition of trash is that it's a worthless product that's thrown out, and that's exactly what these particular petitioners are paying for here, the service of disposing of this in a landfill, just as anyone who wants their trash removed would pay for.
Well, the fly ash has some useful value.
It's absolutely minimal, Your Honor, and I believe that no tax would be placed upon that particular aspect of it. That was dealt with in this determination. In the record right here, we're only dealing with the worthless part of it that's thrown out. I believe that some of the fly ash even is donated free of charge to government entities to use in...
That doesn't make it less useful, does it?
No, I don't believe so. I still think that it's obviously a worthless product. It's something that has to be disposed of in an environmentally sound manner. It's taken to landfills and disposed of just as any trash. And RG&E's argument is, well, there's more of this, therefore it's not taxable. Well, that's akin to saying that a person who has 4 members of a family in a house and generates more trash than someone who lives alone in a house, that the former who generates more trash, that wouldn't fall within this. There's nothing in the statute that indicates that the amount of trash being carted determines its taxability. The end result test, we believe, if applied here properly, the end result of what RG&E is doing and what Seacoast International is doing is maintenance to a building. It's clear that but for the fact that these waste products are disposed of, you'd impair the efficiency, the fitness, and the safety of these particular buildings. It clearly falls within the definition. And as I said, the regulation specifically addresses this and says that a maintenance service includes trash and garbage removal. The fact that Seacoast International doesn't control its haulers, we submit, and doesn't have a trucking fleet of its own is absolutely immaterial. Seacoast has chosen to structure its business in a manner in which it presents one bill to the customer, and that is the waste generator, and that bill has a charge on it for transporting the waste to the landfill and disposing of the waste in the landfill. Seacoast is, in effect, providing the entire service. It's billed that way. Indeed, Seacoast adds a 5 to 10% surcharge to the truckers' hauling fees when it presents the bill to the customers. The disposal issue. mere disposal isn't taxable. I mean, we agree with that. We've admitted it all along. But Seacoast, on this record, has failed to show, before the Tax Commission, and the determination addresses this, has failed to show that any of the invoices used in the test period related to pure disposal. And what I mean by pure disposal is no transportation and no processing. So it has to be solid waste without where the customer brings it itself. Now, Seacoast reads from the record, it points out one invoice and reads contaminated soil. Well, I just turned to that. I wasn't aware of that invoice and read it. It said contaminated soil with oil. I don't know if the oil in that necessitated processing. Perhaps it did. As Seacoast said, in order to be solid, it has to be 85% solid. I have no idea how much oil was in there, and neither does the State Tax Commission when it held that Seacoast didn't meet its burden of proof. In any event, we're talking about invoices which result, and this is once again spelled out in the determination, in $389 of tax liability as opposed to $36,000 of tax liability that was imposed on the situation where there was clearly a freight charge with the disposal fee.
I'm not understanding the disposal distinction. Is what you're saying that if this was merely a fee for taking X amount of trash and putting it on the landfill, let's say, that would not be taxable?
That's correct, Your Honor, as long as there was no transportation.
No
Processing.
Service, no processing.
That's correct, Your Honor. And the tax department has always held that, and indeed landfills throughout New York State right now don't charge
All right.
tax.
Now, they seem to, it seems to be argued that this is not a service or a processing for the owner,
Mm-hmm.
because the owner no longer owns it. It's not returned to the owner, and it's delivered pursuant to these invoices. Does that make a difference?
It would if it was correct, but we don't believe it is correct, Your Honor. The owner has hazardous waste. It's got to get rid of it. It's got to get rid of it in an environmentally sound manner. Therefore, the waste has got to be processed by Seacoast for that owner. And I think Judge Kaye was getting to that particular point. It really is something that's done for the owner to allow this waste to be taken from it and placed in Seacoast's landfill.
Could it be argued that since the hazardous waste is delivered and since the owner no longer has any interest in it, that the processing charge is really a disposal charge?
I don't believe so, Your Honor, for two reasons. Number one, the processing charge is taxed under a separate statute. It's 1105C2. So there's a separate service of processing tangible personal property not for resale. So that's not part of the trash removal from buildings aspect. Number two, I think that the owner does have an interest in that until it's disposed of by Seacoast. We never got into on the record when title passes or risk of loss or anything like that, but I would say once again that the owner, the consumer, the waste generator, still has an interest in this property up until the time that it's actually physically buried in.
What possible interest would the owner have?
Well, the owner has got to make certain that that's done, that the waste is removed from his place of business in an environment and disposed of in an environmentally sound manner.
Isn't that obligation discharged by delivery to Seacoast?
I'm not sure it is.
Would be material.
Well, it may be material under certain circumstances. I think that the fact is that the statutory language itself does not require retention by the owner. And that's what the third department said. They said that if you read the statute, if you read the regulation, neither one of those require that the owner retain any rights in the property. It just has to be the processing of tangible personal property. It says for the owner. But I think that that is different than retention of rights. This is done for the owner in order for that waste to be removed from the owner's property and then disposed of. I think I've covered everything, Your Honors, and in conclusion, we just ask that the orders below be affirmed.
Thank you very much, Mr. Benjamin. Matter of State Division of Human Rights versus the County of Onondaga.
Ready.
Mac?
Good afternoon, Your Honor.
Mac, you rely on Schenectady a great deal for the proposition that there can't be a reinstatement here.
Yes, Your Honor.
But Schenectady was a case of appointment, and the court was very careful to point out that it couldn't substitute its judgment with respect to appointing someone in the first instance. But here we have someone who was employed already.
Well, Your Honor, in that regard, I will make 2 points. First of all, that this appointment was made by the predecessor to Sheriff Dillon, not by Sheriff Dillon.
Can you keep your voice up, please?
I'm sorry, Your Honor. The first point I will make is that the appointment in this case was made by the predecessor to Sheriff Dillon, not by Sheriff Dillon, though I will concede that Sheriff Dillon did retain the appointment, at least initially in his tenure as sheriff. Second of all, I will point out that what I myself believe that the court was intending to hold is that there is a legislative scheme for determining who has the authority of appointment in a specific case.
But this person is appointed.
Yes, Your Honor, this person was appointed by a person other than the sheriff.
Relief in Schenectady would have meant she got something she didn't have before. Relief here will do nothing but restore to the status quo before this happened. Isn't that the distinction?
Your Honor, yes, that is correct. However, again, I would...
Isn't she entitled to that?
No, Your Honor, in this case, I believe she's not entitled to that. And again, for the reasons that there is a specific statutory authority and system for appointment in this matter, and that is vested with the Sheriff of Onondaga County. And obviously, the Sheriff of Onondaga County does not feel that she's an appropriate employee. The Sheriff of Onondaga County, in this case, is personally responsible for her acts, and that, well, as a matter of fact, Your Honor, if I may briefly, Mr. Smith was a short time ago kind enough to provide me with a cite of a case that he intends to, that was not brief, but that he intends to mention, and perhaps this brings out a distinction that I would like to put forth. And that's City of Albany versus Perb, 43 New York 2nd, 954. And in that case, this court distinctly held that, in fact, Perb was granted the authority by the legislature to require reappointment in a civil service matter. I believe that this court in the Schenectady case also held that the Commissioner of Human Rights is not vested with that authority, regardless of whether this would serve to make the respondent whole or not. And that is the contention of the sheriff in this regard. Your Honor.
In Schenectady, we said that the exact language was, since such a direction would in effect deprive the appointing authority of the power of selection.
Yes, Your
And
Honor.
the point that Judge Simons and I are trying to make is that the power of selection was already exercised here.
Yes,
Now
Your
we're
Honor.
talking about re-selection.
Yes, Your Honor. That power of selection was exercised by a person other than the appellant here.
Well, what does that have to do with it? If the discrimination hadn't been practiced here, she would have maintained her job, whether the appellant had appointed her or not. Would she?
Well, Your Honor, with all due respect, it's contended that she was not deprived of her job because of any
Well, all right, I
discrimination.
understand that, but assuming the finding is supportive of discrimination, regardless of whether she was appointed by your client's predecessor or appointed by her, the selection's already been made.
Your Honor, the fact is that she did have an appointment in that position. That is correct. The sheriff determined that that appointment was not appropriate, and that is vested in him to make that determination.
But he did it for unlawful reasons, and that's why she's been reinstated.
Well, Your Honor, that's our contention is it was not done for unlawful reasons, but I
Assuming
appreciate
that it has been.
that it was arguendo. Well, Your Honor, I would still contend that the legislature set forth who has the power of selection, who has the power to make the appointment, and that's vested solely in the sheriff. And that the legislature could have given that power to the Commissioner of Human Rights in assistance of making a person whole that he
Does
had...
the sheriff have the right, however, to discontinue an appointment properly made for an illegal reason?
No, Your Honor, the sheriff can
Then if he does not have that right, what remedy is available to the person who has been deprived of their job?
well, Your Honor, monetary damages for lost wages.
What about the
Are
Royal
available.
Diner case?
Excuse me, Your
What
Honor?
about the Royal Diner case?
Your Honor, I'm not familiar with that case. I apologize to the court.
You don't have to apologize to everyone, just apologize to me, I wrote it.
Well, Your Honor, I apologize to you.
Well, no, there was a case where reinstatement was ordered. Here was a waitress. The owner of the diner was fined, but also directed to reinstate the employee.
Well, Your Honor, in that case, there is no legislative scheme which directs who has the appointing authority. And there is nothing to prohibit the commissioner to exercise that right in making that person whole.
The distinctions between a public and a private employer, though.
Yes, Your Honor. That is the distinction that I am attempting to make.
But coming back to Judge Alexander's question, phrased a little differently, you're not suggesting that the legislature intended to empower the sheriff to discharge someone for discriminatory, illegal reasons, are you?
No, Your Honor, but what...
Assuming that the sheriff did discharge the person here for an unlawful discriminatory purpose, then that action would not be contrary to what the legislature intended, would it?
Well, Your Honor, again, it's my contention that there are several remedies given to the Commissioner of Human Rights, and this is simply not one of them. Another possible remedy that the legislature could have provided is an award for punitive damages.
But think, Mr. Mack, of the policy arguments behind the position which you advance. This would mean that if you ever wanted to get rid of a public employee, all you'd have to do is be in the grossest degree discriminatory against that employee. The employee is fired. The municipality then has to pay damage and so forth, but at least you won't see that employee again.
Well, Your Honor...
That might be a very happy solution for a lot of people.
Your Honor, I'm not suggesting that if an employer does in fact discriminate, which again I strongly contend is not the case here, that there is not a price to pay. I'm just suggesting that this was not one of the remedies that in this case that the legislature provided to the Commissioner of Human
Or in
Rights.
any case, to draw the distinction, in any case where there are public employees involved, you can fire that employee for reasons of discrimination, and yet the only remedy that employee can have is monetary damages.
Your Honor, that would be correct, that the remedy available to that employee is in terms of monetary damages and not in terms of reappointment. In the same way, the punitive damages are also not available to the Commissioner of Human Rights. The legislature could have provided that remedy and elected not to do it. That's not to say that wouldn't have been an effective tool for the Commissioner of Human Rights in a case unlike this where some discrimination was demonstrated. That's only to say that this was a remedy that the legislature elected not to provide to the Commissioner of Human Rights. Now, if I may, Your Honor, in the time I have left, I would like to quote to you a couple of sentences from the brief of the State Division of Human Rights. Page 23, the brief states, the complainant, a white female deputy sheriff, was forced to resign as a result of the sheriff department's reaction to the fact that a black male deputy sheriff came to her house uninvited while he was supposed to be on sick leave. Now, if this statement accurately reflected the record or the commissioner's findings, there would never have been an appeal to the appellate division or to this court. The record, however, does not support this statement, and the commissioner, in fact, did not make those findings of fact. Rather, the commissioner accepted the fact that the complainant had a poor work record. In fact, the commissioner's finding, he sets forth each transgression of the complainant in his decision. Further, this incident referred to was simply the last in a long series of incidents that demonstrated a pattern of behavior that was demoralizing to the department and, in effect, discrediting to the department. Your Honor, the record reveals that the complainant's entire work record was reviewed with her, and that the incidents were discussed with her, and that there was never any reference to either the race or sex of either of the persons involved. In my brief, I've set forth in regard to every significant finding by the commissioner that is intended to demonstrate a discrimination, how this finding is either specifically refuted on the record or not supported by any evidence on the record. Now, I'm aware that I have a very heavy burden to convince this court there is no support on the record, no evidentiary support on the record as a whole to support the findings. However, I believe this is exactly what I have done. A respondent and the counsel for the commissioner, in fact, do not directly address these issues. Rather, as in the quote that I have read, they argue what they would have liked to have seen in the commissioner's finding, not what was actually set forth. And substantial evidence must support his actual findings, not what the commissioner might have found or should have found. To decide otherwise would put me and the appellant in the impossible burden of trying to refute every possible inference that could be made from every portion of the testimony. I would like to address for a moment the test that is urged by the respondent and the commissioner, which would have the effect of shifting the burden to the appellant.
Mac, your time is up, but I'll allow you to, you just to finish that thought if you wish.
Your Honor, if I just may say briefly, the Commissioner of Human Rights specifically rejected the argument that these were similarly situated employees, and the courts in this state have never accepted that test.
Thank you very much.
Thank you for your attention.
Mrs. Smith?
Thank you, Your Honor. I have 4 points to emphasize this afternoon. The first point is that it has been almost a decade since my client, Ms. Cottongim, was discharged from her position by the sheriff. And there is still no definitive decision in this case. That in itself, Your Honors, is a grave injustice. The long delay was caused, I believe, in part by the conduct of the sheriff. I note, for instance, that the issues argued on this appeal are different from the issues submitted to this court on leave to appeal. Thus, for instance, there's the brief of the appellant spends great time and effort to show that there is no substantial evidence. That was not an issue that appellant sought to contest when the appellant applied for leave to appeal. Turning to the substantial, of course the substantial evidence was raised below. It was not raised.
Only in the motion for leave to appeal, you say the point was not raised.
That is correct. Not only, however, is the evidence below substantial, it's overwhelming. That evidence included key undisputed facts. Those can very briefly be summarized. The respondent was a white female. Deputy John Stevens, a black male. They were clearly involved in the same incident. Not a question of what the courts have adopted, it's a question of fact. The fact that they were involved in that incident resulted in Ms. Cottongim's discharge, but only a 2-day suspension for Stevens. On April 26, 1979, Ms. Cottongim was legitimately home on sick leave when Stevens went to her house uninvited. He had called in that day ill when he wasn't, which is itself a violation of the sheriff's rules. He had left his home while on sick leave, another admitted violation of the sheriff's rules. And he had lied to the sheriff's department, about being ill, as I said, when he was not. Nonetheless, based on these facts, the sheriff determined that Ms. Cottongim, a white female, was to be fired, and that Deputy Stevens, a black male, was to receive a 2-day suspension. That was the key evidence that was relied on by the commissioner. It clearly was substantial. It's also relevant to observe with regard to the substantial evidence in the record that the sheriff had taken a variety of demonstrably false positions below as to the reasons for the discharge. Thus, he first claimed that Ms. Cottongim was terminated for abuse of sick time. However, when it was discovered that Ms. Cottongim had missed but 1 day in the preceding year, and that Deputy Stevens had been out the maximum just about every month, and that Ms. Cottongim, in fact, was ill when she was home, he changed his position. That position was taken during the investigation, and in fact was the opening position that the sheriff took at the hearing. Next, the department alleged what I call the boys will be boys defense. It was claimed that Ms. Cottongim was discharged because she acted in a manner that could bring discredit upon the department. When I questioned the undersheriff, Undersheriff Burns, as to what this relevant conduct was, he said it was because she was at her house with Deputy Stevens while both were on sick leave. The problem with that formula, of course, is that logic would mean that Deputy Stevens also discredited the department, which would have required, I presume, a similar penalty. Interestingly enough, and much to my shock and surprise, Undersheriff Burns said, well, no, what Deputy Stevens did wouldn't have brought discredit on the department, but what Ms. Cottongim did, that did bring discredit on the department. The reason I call that the boys will be boys defense is because what the sheriff is saying is that we can't blame the boys for their peccadillos, but we must punish women for luring the boys into trouble. Recognizing, however, the inherent problems with the boys will be boys defense, the sheriff abandoned it and invented what I call the Ratfink rule. Thus, he testified that Ms. Cottongim's discrediting conduct was that she hadn't advised the department of Deputy Stevens' violation of department rules. The troubles with that defense are numerous. First, the sheriff candidly testified that the rule had never existed before, that in fact it was invented for Ms. Cottongim. The rule was not in writing, had never been orally announced, had never been enforced before, and in fact, no one had ever previously been punished for its violation. Second, not only had the rule never existed before, but its application here was absolutely absurd. The department knew of Stevens' rules violation before Ms. Cottongim, because when he first called in the morning, he said, I need a personal day. And when they said no, he called in again and said, well, then I'm sick. So they said, okay. And then he called in again and said, well, I'm really not sick. I'm having my car repaired. So the department knew about everything before this happened. Next, of course, he shows up at her house, followed thereafter by Internal Affairs, who says, my God, is Deputy Stevens here? Cottongim says, yes. He says, can I use your phone? Sure. He goes in, calls up the sheriff and says, Deputy Stevens is here, and Ms. Cottongim is standing there. So she knew that the department knew, the department knew. Third, of course, the incident would not have discredited anybody. It had taken place in the privacy of her home. Unless, of course, what the sheriff's real concern was that someone would find out that a white deputy, female deputy, had a relationship with a black male deputy. And that, I submit, was what was going on, and certainly the record is clear enough for the commissioner to agree that that was the cause for the discharge. The second point that I wish to make concerns the alleged poor record. That really is not the issue here. The issue is one of motivation, and as I submitted, substantial evidence. Was the sheriff motivated by Ms. Cottongim's sex, and or was he motivated by the racial relationship, interracial relationship? That is, was there substantial evidence to support the commissioner's determination that the sheriff was so motivated? As I've said, I think I've recounted the high points of the uncontroverted evidence and testimony that shows that there was such animus. Could also point out the speed of the decision also demonstrates that animus. But there's another important point, and that is that there exists no evidence that Ms. Cottongim was disciplined in any way prior to Sheriff Dillon's term in office. The sheriff testified that the existing records were unreliable, and he testified that she hadn't been disciplined under his regime. Moreover, the determination to fire her didn't come about as a result of the alleged prior record. It came about because of the incident at her house. Everybody's agreed to that. The sheriff testified to that. The undersheriff testified to that. The personnel commander testified to that. She didn't have any problems in her record. I see my time is up. I wanted to address quickly, if I could, some brief...
Not really. We gave you all the time. And, if you want to say one more sentence, go ahead.
What I wanted to say about Schenectady
That's the sentence.
was that... I had more than one sentence. In the city of Albany, the court recognized the power to make to undo a discharge. This court recognized that. That's what's at issue here, and I think that it's clear that under those circumstances, the reappointment, shall we say, is appropriate.
Thank you, Mr. Smith. Ms. Downey?
Good afternoon, Your Honors. Just to pick up on the Schenectady point, I think it's very important to point out that whereas a different sheriff had originally appointed Ms. Cottongim, she was a deputy serving under Sheriff Dillon for some 16 months, and I believe was automatically reappointed by virtue of her service under him during that period of time. And any suggestion that he's not responsible for what he did because he didn't make the original appointment 4 years earlier just isn't grounded in fact at all. And just in that regard, it would certainly gut the human rights law with respect to public employment if, as Judge Walker suggested, there were no remedy for getting rid of people in a Schenectady situation, and hiring the division is able to make orders that a person be considered in the one of three civil service situation without the discrimination that has been shown, but no such order would be possible here if we can't order the person back. Just want to make a few points. The Complainants Council has covered the facts pretty well. The argument is raised that the commissioner didn't have the authority to make the order that he did because the ALJ reached a different conclusion in his proposed order, and I don't, this was not addressed by counsel in his argument. I don't think it takes much time. The rules of the division and the human rights law require that the commissioner make the final order, and all rights are his with respect to drawing inferences from the facts and making findings of facts. The only area where there'd be an exception to that would be in a case where the demeanor of a witness has been commented on by the administrative law judge, and that was not the case in this case. There were no demeanor or conduct of witness kinds of findings. And just with respect to the substantial evidence, you know, it was very clear to the commissioner, I think, that throughout these proceedings, the Sheriff's Department was not able to come up with a consistent or credible reason for its employment action. And this falls very clearly within the analysis is set out by the Supreme Court in Burdine versus Texas Department of Community Affairs, that shows that a pretextuality in a proffer justification by an employer is the equivalent of a finding of motivational discrimination or a discriminatory motive, because discriminatory motive is not often easily discovered. And in Burdine, the Supreme Court said that can be discovered in any one of two ways, or discrimination can be proved in any one of two ways, either by showing that a discriminatory motive more likely was the reason behind the employment action, or that the reasons given just lack credence, and that was so found by this commissioner Actually, both instances, both directly and indirectly, the findings of discrimination should be upheld because the flip-flopping, as complainant's counsel has set out, the flip-flopping with respect to what the reason was shows pretextuality. And the fact that this was a rule that was developed for the complainant alone, no one had ever, according to the undersheriff, no one had ever been fired for discredit brought upon the agency, upon the sheriff's office, and the disparate treatment between the male and the female here, that she was, the male, interestingly, was not even charged with this amorphous rule infraction of bringing discredit on the sheriff's department. His very minor punishment of 2 days suspension was for sick leave abuse and for having assaulted a juvenile prisoner who was in his custody. And I think as an aside, in the sheriff's brief, the double standard that was the basis of this case from the very beginning is continued, because the complainant, who had nothing to do with that assault on the commissioner, except she, on the prisoner, except that she was there. There was never any allegation that she had anything to do with it. It's imputed to have had something to do with it in the brief.
I'm sure
and
this
there's
is
just no-
in the record, but apropos of the discharge itself, what disciplinary proceedings or hearings took place? I'm not talking about the human rights violation.
Right, with
I'm
respect to the
talking about-
complainant here?
Yes.
Well, she was actually informed within 90 minutes of the internal affairs officer being at her house. She was called by the personnel commander and told she was going to be fired because she'd been caught with John Stevens. That was
What happened thereafter?
She then asked to meet with the sheriff. It was really a fait accompli as of that time, really, except she took the action of asking to meet with the sheriff, and an appointment was set up for the next morning. And she met with the sheriff and Under Sheriff Bialk, or Under Sheriff Burns and Chief Jailer Bialk, at a meeting in which she was told that the sheriff would not put up with such goings-on, and that the deputy's car had been seen outside her house on several occasions, and at that time she was told either to resign or she would be terminated. And there was no further...
No hearing?
No. Now, she was not, it was not required that she have a hearing,
Yeah.
but no,
Right,
that was the
because she
extent of
not
it.
civil service.
Yes, that's right. That's correct. I just wanted to point out, again, that with respect to the poor performance, that it's just been a smokescreen that has been raised here. And over the 4+ year period, there were several scattered incidences, which is what the commissioner found. And none of them was ever resulted in any kind of disciplinary action taken against her. The record doesn't show that they were ever even resolved. Her personnel file is incomplete, and the sheriff admitted that there are frequently times in which an employee is accused of things that he or she doesn't do, and that it doesn't always show up on the record what has happened. And to proffer those as being some kind of, inexorable procession that led to this day when she did this terrible thing, which was obviously nothing. I mean, there's really nothing that you can say that she did that day that violated any rule that the sheriff's department has shown the division, and to that extent, the division was, the commissioner was entirely within his prerogative of finding discrimination in this case.
Thank you very much, Ms. County. Insurance Company of North America versus the City of New York.
If it please the court,
You said the insurance policy issued to the receiver here ensures the interest of an owner, and therefore, under the administrative code, the City of New York could properly enforce its lien.
that's correct, Your Honor. That's our theory of the case. This case is a matter of statutory construction.
Does it make a practical difference if the receiver gets this money? You have a priority claim in both cases, don't you?
Yes, but if the receiver gets the money, then...
I'm trying to figure out what we're fighting about here. You're the first man in the cell either way, aren't you?
No, if the receiver gets the money, then the receiver has the money for all purposes, and our tax claim expires. if the property has been destroyed.
You want a priority over the funds.
That's correct, Your
I
Honor.
thought you would have a priority for unpaid taxes even if it went into the hands of the receiver, no?
Yes, on the receiver's theory, the city does have priority, but the receiver ends up with the money and the city ends up with its priority, and we'd prefer to have the money. That's the point of this
That's what I'm
exercise.
driving at. You're first to get the money in either case. It's just a question of whether it goes through the receiver's hands, isn't that so?
No, because once the receiver has the money, we have no way of collecting our delinquent tax. The property,
Well,
the property is out there. I'm sorry, we can go through it in rem foreclosure on the property.
You would have first priority, would you not?
That's true, but we would have to go through the process of foreclosing on the
You'd rather be
property,
paid now than
selling the
later.
property.
That's what it amounts to.
That's correct. As I say, we want the money. We know we have the priority. Anyway, as Chief Judge Rottler pointed out, this case is really a matter of statutory construction. It concerns a provision of the administrative code which gives the city a lien for unpaid real estate taxes on fire insurance proceeds where the underlying policy, quote, ensures the interest of an owner. The legislative history reflects two purposes for this statute. First, of course, is to discourage arson by denying the proceeds to the potential perpetrator. The second purpose, which was ignored by the courts below, was to permit the city to collect its unpaid taxes where the property, which under the real property tax law is the sole security for collection of tax, where that property has been damaged or destroyed by fire. In other words, this legislative concern arises out of the in rem nature of the tax, and the statute ensures that the city's tax claim will survive and be collectible even though the property has been destroyed or impaired. Now, in the instant case, the fire insurance policy was taken out by a court-appointed receiver who was holding the property during the pendency of a mortgage foreclosure action. The property was damaged by fire. The city and the receiver disputed the fund. Special term awarded the fund to the receiver.
May I stop there?
Sure.
Ask if that is so, and if the insurance policy is taken out by the receiver in the name of the receiver, for the receiver, how do you get by the first hurdle that it ensures the interest of the owner?
Well, our position is that it is Hornbook law that the receiver himself has no interest in the property. In this, as the term interest is generally used in law, an interest means a pecuniary or financial interest. Particularly in the context of insurance law, interest is defined by statute as a substantial economic interest in the property. Now, it is Hornbook law that a receiver has no such interest. Rather, a receiver is a fiduciary who's holding the property to administer it and protect it on behalf of those persons having such financial, pecuniary, or economic interests.
Well,
And just to finish my
assume
thought.
There is or might have been an insurable interest for the owner, but he didn't insure it. Does it make a difference?
No, because the cases hold that the owner has a legal interest and in fact has an insurable interest. Even if that owner is a defaulting mortgagor, that owner's interest continues up until the time of foreclosure and sale at judgment. And those considerations are brought together in the 149 Clinton Avenue case cited in our brief.
That may all well be so, but the owner here did not insure it. The only person who insured its interest is the receiver. Does it make a difference?
Yes, because no, it does not make a difference whether the owner or the receiver insures it, because, as we argue in our brief, the receiver is a fiduciary. He's insuring it for somebody else. He can't insure it for himself because he has no interest. He has no economic interest to insure. the interest he must be insuring must be that of a person with such an economic interest, and the owner is such a person. Therefore, it is inescapable, really, that the receiver's policy ensures the interest of the owner.
Are you arguing then that the receiver has no insurable interest?
He has no, if you mean by insurable interest, can he take out a policy? The answer is yes, he can. If you mean does he have a substantial economic interest, which is the way insurable interest is defined in the insurance law, the answer is no, and there are many cases holding that he has no title, no interest in the property, no pecuniary interest, and that he is there to protect.
But he has all sorts of obligations, perhaps as a trustee.
Yes,
and if he doesn't insure, he's liable. He must insure.
He must insure. In fact, one of those obligations is to insure the property on behalf of the owner. And what the 149 Clinton Avenue case does hold is that the owner who is a defaulting mortgagor has a right of action against a receiver for failure to take out fire insurance on the property. And that arises out of the fiduciary relationship between the receiver and the owner.
The receiver also has an obligation to an owner. Isn't that so?
Arising out of their fiduciary relationship.
Isn't that an insurable interest?
No, because an insurable interest is defined by statute as a substantial economic interest in the property, and that is what the receiver does not have.
Is it a potential liability of substantial economic interest?
No, I don't, not the way that that term is defined in the insurance law as being an interest in the property. And I believe for the purpose of the receiver's other liabilities, I don't believe one looks to the fire insurance proceeds for that. The fire insurance proceeds are intended to be the replacement value of the destroyed property. They go only to the receiver's obligation to maintain the property and protect it from damage and waste. They don't, those proceeds cannot be applied to any of the other receiver's liabilities. They are really a substitute for that property. I want to also point out that the city's construction of the statute is no obstacle to the receiver's legitimate purpose of repairing and restoring the property. The statute does provide a convenient administrative procedure whereby the receiver or any person with a bona fide intent to restore the property may obtain the fire insurance proceeds even after they have been taken by the city pursuant to its tax lien. The incident record has no explanation of why this receiver has ignored that convenient procedure and instead followed the route that has brought us here today. In summary, I would like to ask this court to interpret the statute as the legislature wrote it and to reverse the decision below. Thank you.
Thank you very much, David. People versus Daniel Knack. Panaro, we have a guilty plea here, do we not?
Yes, we do, Judge.
Isn't that admitting all the facts of the felony?
Judge, normally that would be true. However, in this case, they were negotiated pleas. This was extensively conferenced. There is an express reservation of the right to not withdraw the motions that have been decided by the court below, and that you'll find, Your Honor, at record at page 66 of this court. Normally, a guilty plea would waive the right, but we expressly reserved it. And secondly, here it's jurisdictional. A guilty plea in this court is held time and time again waives only non-jurisdictional defects. As my argument will develop, this is a...
You say it's jurisdictional because you should have had the right to challenge in a suppression context?
It's jurisdictional for two reasons. One, we should have had the right to challenge it below, and two, the guilty plea itself, we are admitting that my client was driving an automobile, and at the time he was driving the automobile, he was intoxicated. Unfortunately, because the motion to controvert was denied, as part and parcel of that special information elevating it to a felony, my client admitted that he was convicted of the prior misdemeanor DWI in Suffolk County. However, that doesn't mean that the prior misdemeanor conviction was not constitutionally infirmed. That is the whole point of Balzadar. The reason we are here today, in my opinion, Your Honor, is because Balzadar has caused substantial confusion among the lower courts. And one of the reasons it has caused so much confusion is because Lewis v. United States, which was decided just 2 months prior to Balzadar, reached a different verdict on almost the same set of facts. Both cases are United States Supreme Court cases. The problem with Balzadar is that it is being read wrong by the appellate division and by Judge Lawrence below. If Mr. Knack was limited to quorum nobis, as everyone is seeming to say he was limited, Judge Lawrence said, go to Suffolk County, make your motion in Suffolk County. Appellate Division, Second Department, Judge Niehoff, unanimous decision, go to Suffolk County, make your motion in Suffolk County. If Balzadar was met with that type of reasoning, he could not have gone to the Supreme Court of the United States. There was no statute in Balzadar that allowed Mr. Balzadar in Illinois to make the type of motion he made. He had a writ of quorum nobis open to him. Justice Brennan, Justice Marshall, all the majority opinions, Justice Blackmun point that out. But they say this is a fundamental right guaranteed by due process. And that right is protected by the Constitution of the United States. And since there is a fundamental right, that motion does lie. If Balzadar had to go to Illinois to make a quorum nobis motion, it very well may be that Balzadar would have lost that quorum nobis motion. That doesn't mean that it's not unconstitutionally infirm for purposes of elevation. Now, I point out, this is...
You lost me somewhere along the way. The fact that you have the opportunity to make a 440 would satisfy due process, would it not?
For some purposes and not for others. And that's exactly what Balzadar says. Justice Brennan says in his opinion at Balzadar, and I quote this for the court, that an uncounseled conviction does not become more reliable merely because the accused has been validly convicted of a subsequent offense. For this reason, a conviction which is invalid for the purpose of imposing sentence of imprisonment for the offense itself remains invalid for the purpose of increasing the term.
But that's dealing with enhanced punishment.
Correct.
For which we have a special statute here as far as challenge is concerned. But this is not enhanced punishment.
It is. Mr. Knack has been enhanced in punishment in that he is receiving up to, or could be receiving up to 4 years in prison on a charge that he could only receive up to 1 year in prison for,
Why can't
but
you
for
say
the
that? Why
elevation.
can't you say in this instance that the prior DWI just puts the defendant on notice that the next time it's a felony?
It does. There's no question about that. However, a constitutionally valid prior DWI puts the defendant on notice that the next time it's a felony.
In other words, the point I'm making that it establishes a status as opposed to enhancing a punishment for a particular crime. It establishes a different status by virtue of the prior conviction. And this then would give it a different light as far as considering 440 in the limited context that you would have us consider it.
That's true in Balzadar as well. In Balzadar, he went and stole bacon. Because he was convicted of stealing some petty bacon, which is normally a petty offense, he had a misdemeanor conviction in the state of Illinois. A couple of months or a year later, he went and stole a $29 shower head, another petty offense, but for the prior. That prior made the shower head case a felony, and he was so prosecuted on the felony.
It changes the status of the crime? Did it change the status, or did it change the degree of punishment which could be meted out?
It changed, I believe, the status of the crime. It changed it from a misdemeanor to a felony. He was prosecuted for a felony in Balzadar. Now, Lewis reaches the exact opposite conclusion, but there is a reason. And it took me quite a while to figure it out, but there is a reason. Lewis deals with a civil disability, which you can enforce with criminal sanctions. In Lewis v. United States, Lewis possessed a firearm, and he was arrested. The reason he was arrested is Title 18, Section 1202 states that any person convicted of any crime cannot possess a firearm, or he's guilty of this offense. Lewis is prosecuted, and he challenges the prior any crime. And he is arguing, since that was constitutionally infirm, that he can't be convicted of 1202 violation. The majority found that he was wrong and that they upheld the conviction. There is a 6-3 opinion in Lewis. There is a strong dissent, but even the majority opinion is a civil disability finding, only enforceable by criminal conduct. It is not a criminal case to begin with. He could have applied for relief from civil disabilities or for a gubernatorial pardon to possess a gun. You know that when you want to possess a gun, that if you have a crime on your criminal record, that you have to apply to get that criminal record off your record. With all due respect, no one plans on a subsequent DWI, and you don't make a motion, may I please be relieved of my prior misdemeanor conviction. It was constitutionally infirm because on the next one I wanted to remain a misdemeanor. It doesn't work that way. With a gun, it would. So that's the distinction in Lewis. Also, quorum nobis is much, much different than what we are trying to do here. Quorum nobis, you get rid of the whole conviction for all time, forever. We are not trying to do that here, Your Honors. What we are trying to do here is we are trying to suppress it for this particular reason and this particular reason only.
So, Mr. Panaro, if all your arguments are persuasive, and of course for myself alone, we don't know where we come out, but if all your arguments are persuasive, ultimately you're asking the court to add a remedy in the statutes and in the CPL to those that already exist with respect to Article 440, with respect to enhanced punishment procedures, with respect indeed to suppression itself, because this would be a new kind. Isn't that so? It would be a judicial remedy that you would ask us to legislate on top of those that exist.
Absolutely. That is conceded. It is in my brief. That is exactly what the courts in Solomon, in Dawn, in Ryan all do, and I understand that they are lower court decisions, but that is exactly what they do. Sirianni, which is a Fourth Department case, Your Honor, reversed by this court later on, but on different grounds. It was reversed on, not on the procedural reason, but it was reversed on the ground that a person does not have to be told that the next DWI is a felony in order for the prior to be constitutionally valid. The Fourth Department is the one who reversed Sirianni. They remain silent as far as the procedure, and in their silence, impliedly, they affirm the procedure itself. I am asking this court to create a so-called Knack hearing, but it's only fair.
You recognize what an extraordinary burden that is for you to persuade us to do that. I mean, I assume you would argue that you wouldn't be satisfied with us telling the legislature that, by the way, you've provided all these remedies. There may be a gap. You may want to consider another one. That wouldn't satisfy you.
Judge, it's been told to them, and it hasn't worked. It's been told to them by the Solomon Court. There's a very carefully reasoned decision in that case, a very analytical decision, and one of the judge's specific lines in the decision is that he calls upon the legislature to correct this obvious wrong.
The fact that they have not done so, is that a weighty consideration that adds even further to your burden then?
No. The fact, Judge, that my client is suffering in this case a constitutional unfairness would outweigh the reasoning that is set forth. My client's constitutional rights come before anything else in this case to my client, and what we are saying is that under Judiciary Law Section 2B, this court and the courts of this state do have the power to create a remedy where they perceive a wrong and there is no remedy. That's exactly what Balzadar did. Again, in Balzadar, in Illinois. And what's interesting about Balzadar is Balzadar finds that the prior misdemeanor conviction would be constitutionally valid for all purposes, except this one. In Balzadar, what they say very clearly is, well, under our decision in Scott v. Illinois, that otherwise unconstitutional plea or conviction would only be unconstitutional if Balzadar actually went to jail. Balzadar did not actually go to jail below, I'm sorry.
Just one question. The cases that you've alluded to are or are not cases where there's been a prior adjudication, as there has been here under a 440.
That is correct, except for People v. Ryan.
Are they? Or they're not, except for the one?
Except for People v. Ryan, you are correct, Your Honor.
Does this fact make a difference?
No, and I'll explain why. I don't
Because
believe...
it seems to me the very issue that you sought to raise in the suppression motion, which is an issue here, was raised in the prior 440, which went to the appellate term and not beyond.
That's true.
Why haven't you had why has your client not had his day in court?
I knew you were going to ask that. Exactly, my exact words are, why has your client his day in court?
Well, we got the question, now what's the answer?
All right. The answer goes along with what I was just saying. The answer is, if I was forced, which I was in this case, I was told by the judge and by the DA, go to Suffolk County, and I did that. But just because I lost in Suffolk County doesn't mean I should lose in Nassau County. The reason is exactly the same as in Balzadar. It is constitutionally valid in Suffolk County. There's no reason to set this aside under the holding of Scott v. Illinois. My client did not actually go to jail on the first DWI in Suffolk County. There really is no reason to set it aside in that case. But that not being the issue before you judges, the issue here is it constitutionally valid for purposes of enhancement? That's where Judge Brennan and Justice Marshall and Justice Blackmun and Justice Stewart say, just because it's constitutionally valid for all purposes, which it might be, doesn't mean it's constitutionally valid for enhancement. Now, I did make a 440 quorum nobis, and I lost a 440 quorum nobis. But that doesn't make a difference in this case. If